Hi, everybody. It's Elektra, artist, visa lawyer, and entertainment lawyer. I'm here to talk to you about an RFE that we just beat. But just to remind everybody, I'm the attorney at Yale Law Group. It is my firm. We've got offices in New York and New Jersey, but we work with clients all over the world. In fact, this client that I'm going to tell you about actually lives in Arizona. So I hope that you guys have been tuning in to watch my roundtables. Every Friday, I'm organizing a roundtable, hosting a roundtable with different women in celebration of Women's History Month. This week, our roundtable is going to be about law school and about the law school process. We're going to be talking to a professor, a law student, an LLM law school graduate. So it's going to be a real treat to talk to them about their experiences. But today I wanted to talk to you guys about RFEs. So I think that a lot of the times, RFEs are a little bit difficult to tackle because you don't know what they're asking. You're not really understanding what's going on because what they're asking for, you've already submitted. So it can be a little bit confusing. I really hate RFEs. We really don't like them in our office. This is why our filings initially are as tight as possible. I try to include every piece of evidence that I feel will qualify and will explain my client's trajectory, my client's career, just because I want to be as tight as possible. But they do happen statistically, and RFEs do happen for strong cases and for weak cases. But what actually happened to me was actually quite embarrassing for USAS. So let me tell you what happened. So I represent the world's top, like they're classified in top 10 in the world ballroom dancers. So actually quite known. It's a couple. They dance together. They've won almost every major competition in the world, top 10 for ballroom dancing. So I was very confident in their cases, and I actually filed both cases together. Remember, we're talking about a couple that dances together, ballroom dancers, top 10 ranked internationally. So not only in their native country, but also internationally. So kind of superstars in their field, ballroom dancers. So file the case at the same time, very similar profiles because they've been dancing together for their whole life. Or for their whole career, rather. So we file the case and the male dancer gets approved. Great. So now I'm just waiting on the female dancer, the partner of the male dancer. And we actually get a pretty horrible RFE. Now, when you get a horrible RFE for these types of cases, for two people who have the same career, the same trajectory, the same awards, you kind of think about like what's actually going on in the adjudicator's mind. Why would a case be approved and then that very same case, the only difference is the sex, the gender of the person, why would that case get a horrible RFE? So it makes you think about the adjudication process and whether or not the judging of the cases is actually streamlined and equitable, and whether or not they're actually applying the same criteria and the same analysis for all the cases. The answer obviously is no, because same case filed, male got an RFE. No, hi, Rowie. This is not a VAWA case. This is actually an O1 case, O1A, because ballroom dancing is considered to be a competitive sport. So this was an O1A. O1A, most people who know about O1As usually file them for startup founders, file them for teachers, file them for those in business. So these two dancers were competitive ballroom dancers, which is considered to be a sport. And male got approved, no problem. Horrible kitchen sink RFE for the female dancer. So how did I approach this? I knew that this was a very, very delicate situation because if the female dancer didn't get approved, that means the male dancer could not actually continue to perform because they're known internationally as a couple. They dance together. It's not like the male dancer could continue his career or the female dancer could continue her career in her home country. I needed to get this case approved because these are dancers that dance together. They compete together. It's like a package deal. So being very, very mindful of the sensitive situation for these clients, I decided to focus on the tone and the style of my RFE. I'm usually very aggressive with RFEs. I usually point out all the mistakes in their analysis, point out all the case law, everything that they're doing illegally. But I took a step back. I made a strategic decision to take a step back and to really focus on the hardship that would ensue if my client, the female dancer, wasn't approved. Now, hardship is not any sort of factor when it comes to an O1 analysis. But again, I wanted to be creative and really speak to the heart of the case, because in essence, basically, if you just break it down, you take away the immigration stuff, this is just a couple and they dance together. They're pretty good at dancing. They win together. They don't win individually, and they want to keep dancing. They want to continue to pursue their career competitively together in the US. So instead of being really aggressive and pointing out the issues in USCIS's analysis, I focused on the hardship that would ensue if this couple could not continue to dance together, what it would mean, the destruction of the career that they have built years and years and years together working on, what it would mean for both of their careers to die, because essentially that's what would have happened. If I didn't get this client's case approved, they would not have been able to continue to dance together successfully as a couple. They would have had to make the decision to go back to their home country because part of the couple would not have been able to dance. So the first part of my RFE response focused on the hardship. Number one, the hardship that it was causing the male dancer to not be able to continue to perform with his female counterpart. I also focused on loss of income. Because they are a package deal, my male dancer client was not able to make money dancing and competing because he was missing his female counterpart. And the third thing that I focused on was pointing out to USCIS that they really need to have a cohesive adjudication. It cannot be one standard of review for one client and a different standard of review for another client. That cannot happen. That is unfair. That is illegal. And I pointed that out, and I let them know, like, listen, the case of the male counterpart dancer was approved without any issue. The exact same case with the female dancer received a pretty harsh RFE. Now, not only is this RFE process causing hardship to the client and to his career and for his ability to continue to compete competitively in the US because they are ranked in the US, but it's also causing a substantial loss of income because they can't continue to dance together. And number three, the adjudication process has not been fair because the same standard has not been applied to the female dancer, to the female counterpart. And I was pretty confident in my response. And as predicted, the case was approved within 5 days. Now, the reason why I want to talk about tone and style is because every case is different. Every officer is different. And even though there should be the same standard of review for these types of cases, unfortunately, that doesn't happen. So you really need to have, when you're approaching the RFE, you have to have a really strategic mindset, because I think that had I chosen to be aggressive and really pointing out the holes in the RFE that was submitted, or the RFE notice, I don't think that it would have had a positive outcome on the client. So I chose to be very delicate and pointing out these actual soft factors that I usually don't argue for O1 cases. I never argue hardship. I never argue loss of income. And I certainly don't make the officer feel as if the cases are not being adjudicated at the same level, because I don't want to insult the intelligence of an officer. So I wanted to tell this story because I want to really point out that all cases are different. all RFE notices are written differently, and an experienced attorney can really understand the tone of how the RFE is written. And sometimes, even if it is a boilerplate RFE, which I did get in this case, sometimes you can really ascertain the style, the tone, and the spirit of the officer who's adjudicating the case. So I want you guys to be really, really careful about these RFE notices, and be strategic in how you choose to answer them, both in tone, both in style, and both in the arguments that you choose to bring forward. Of course, I argued case law. Of course, I argued the statutory language that protected the client. But like I said, I took a step forward and argued different factors that normally don't apply to O1, such as hardship, and loss of income. I really think that that's what made the difference. So for those of you who do have RFEs and who are unsure about how to approach them, you want to be very, very careful in how you're deciphering and decoding that RFE with the attorney who you're working with, because you want to make sure that you're taking great pains to really understand the tone and the style of the officer who's drafting that RFE notice. So I'm very happy and pleased to announce that our client was approved in 5 days, pointing out these factors, and that they will continue to be able to perform together and to dance together and to compete together at a professional level here in the US. So if you have any questions about RFEs, or if there's something that maybe irks you about your RFE response, make sure that you're looking at it sometimes with a fresh pair of eyes. Make sure that you're really exploring all of the aspects of the RFE, not just the different categories that haven't been met, but also the external, maybe soft factors that can actually happen, or that can actually be argued to win a case. That's very, very I think important to responding creatively, but also effectively. Effectively meaning you want to win the case for the O1. So with that, I hope that this was helpful. I hope that my client's experience will be of service to whoever's watching. And if you have any questions, feel free to send me an email. Let me know if there are any specific topics you want to cover. And I hope that I can shed some light and provide some information for you guys. So thank you so much. It's the beginning of the week. It's Monday. Happy Monday, everybody. But I hope everybody's getting a great start to their week. It's a very exciting time because spring is coming, and people are graduating from college. You want to make sure that you're making the right choices during your OPT to create a strong professional profile. What I'm seeing now from my consultations and from clients is that people are taking a little bit of time, not a little bit of time, maybe they're coming to a lawyer later rather than earlier. So you want to give yourself your best good faith effort at whatever petition you want to file, and really make sure that you're exploring all of your options. And if you're on your OPT, maximizing your time. So thank you everybody for watching, and please join my clubhouse on arts and immigration. Follow me on TikTok, ask questions, I will respond to them. And if you haven't joined my exclusive private Facebook group for O1 visas, join so now so that you can get exclusive information on O1 visas and artist visas. And tune in on Friday for my Women's History Month Roundtable, where we're going to be talking about law school. We're going to be with a law school professor, a law student, a law school graduate, and I will be asking them questions to shed light on what their experience is and how you guys can apply to law school and become a lawyer like me. So everybody have a good night, and I will speak to you soon.